Thanks for staying with us, and those who've just joined the program this evening, my guests are Tony David and Gordon Stewart. We're talking about estate planning, and I've got a question here for Gordon. Does it matter whether your trust is registered in Mauritius or any other place?
Jeez. Great question, Brian, and one that I get asked on a regular basis. Maybe if I could just use a quick analogy to a South African trust. So a South African trust is established in South Africa, falls under the Trust Property Control Act. The trustees sit in South Africa, and the assets are invested in South Africa. Once you move outside South Africa, that whole thing falls away. So there's three legs to this. The first leg is the governing law of the trust, and that will be stipulated in the trust deed. And what the governing law simply means is that if the trust ever has to go to court, it's that jurisdiction where the case must be heard. So you can choose your jurisdiction. We use Jersey because Jersey is kind of internationally recognized as one of the leading trust jurisdictions, as well as that it's been around for hundreds of years. So there's a lot of case law and precedent. The next one is where your trustees sit. And in essence, this is where the place of effective management or central management of control of the trust is. And that's where it determines where the trust will be a tax resident. And then the last one is where the assets are situated. And offshore, you can invest pretty much anywhere. So coming back to your question, does it matter where your trust is registered? Typically, what you're looking for is a jurisdiction that has a well-established trust law, so that there's a lot of precedent, case law, and that there are support staff or support companies who are able to actually handle that trust. So attorneys, barristers, accountants who've specialized in trusts, etc. So yes, it does matter where it is registered. And as I say, we use Jersey. Nothing against Mauritius trust law. It's only been around for about 30 years, whereas Jersey has been around for hundreds of years.
Thank you. Tony, when we talk about trust, just explain the changing landscape. I mean, you know, South Africans dealt differently with the trusts, the way offshore trusts were handled for many years. Grey listing, you know, I'll give you an example, and just to let you know, I've had a bank account with NatWest over 50 years. They've now told me they're closing the bank account. I'll have to move the funds, not substantial funds, to another account because they're no longer prepared to deal with someone who lives in South Africa. Unless I can prove to them that I live out of South Africa, they're closing my bank account on the 23rd of May.
Brian, this is all about, you know, money laundering and related matters where trusts have, unfortunately, certain trusts been misused to hide beneficial ownership. So there's a requirement now in South Africa, FICA legislation, effectively, which requires that beneficial ownership of trusts, and that is not merely technically in law the trustees, but also the trust beneficiaries, must be provided via a portal to the Master of the High Court, so that it can be traced, even if it's a discretionary trust, as to who benefits or could potentially benefit under that trust. And that's the way of obviously combating money laundering.
So now the old days where the settler became the main spokesman for the trust, and everyone just signed, and that's what now.
Well, there's also, Brian, aside from money laundering laws, there's been development of our case law, which where there have been attacks on sham trusts, or what's called own ego trusts, where the trust is merely a replica of yourself, and you as a settlor are managing it. That's no longer the case now. You've got to actually make sure you have resolutions. All trustees, whether they agree or not with the decision, must participate in that decision-making process, and you've got to have that on record.
Gordon, one for you from Leslie in Witbank. She says, are beneficiaries entitled to get trust information, and is there any significance to the way beneficiaries are defined in the trust deed?
Can I just quickly come back to a comment that Tony made, because I could not agree with him more, and I just want to re-emphasize it because a lot of trustees get it wrong. Let's say there's 3 trustees. and A and B decide on something and they forget to, or they deliberately choose not to tell C. And then they go back to the trust deed and say, well, this is a legitimate transaction because the deed says the majority decision prevails. That's not how it works in reality. All of the trustees must be aware, and thereafter it goes to the decision-making process. You cannot exclude a trustee or informing a trustee of a particular transaction or an event. But to come back to Leslie's point, yeah, it's a good question. And if my memory serves me correctly, I think the leading case in this was Doyle versus the Board of Executors, which then held that, yes, beneficiaries are entitled to a certain amount of information about the trust, if they're a beneficiary, obviously, and the trustees do have a duty to disclose that information. So typically what we would say is that the beneficiaries have a right to see the financial statements. They are the identity of the trustees and the assets within the trust, as well as the trust deed itself. So therefore, kind of if I had to wrap it up in a nutshell, beneficiaries are entitled to receive information from the trustees relating to the benefit that they are due to receive. And then I think you also asked about any significance to the way that the beneficiaries are defined. Yes, because the wording will determine the rights of the beneficiaries to determine whether they're income or capital beneficiaries.
Okay, a lot together. Tony, this is one you love, and I know this is what you've been dealing with. But Philip in Westcliff asked the following: what is the risk of taking SARS to court when they refuse to even discuss a dispute? And who can represent a disgruntled taxpayer in a tax court? Is it reasonable that the Constitutional Court is hearing tax appeals? And I know you mentioned to me that your days and hours and even your weekends are taken up with these disputes. What's happening there, Tony?
Look, Bryan, a sister act to the Income Tax Act is called the Tax Administration Act, and that governs, together with regulations called rules, the proceedings of a dispute with SARS. So we go through an objection, an appeal, possibly alternate dispute resolution. Then if it's $1 million or less in dispute, tax board. If it's above $1 million, tax court. Then we can go to the High Court, then the Supreme Court of Appeal. And more recently, there's a trend to appeal from the Supreme Court of Appeal through to the Constitutional Court. So it's certainly the forums are all available, but it's time and money. In my view, the Constitutional Court, although it is allowed to hear matters of what's called, there was an amendment, an extension of the jurisdiction of the Constitutional Court in about 2012 to allow the Constitutional Court to hear other non-constitutional matters, which could then include tax matters, provided it is of what they call general public importance. I've got a slightly maybe jaundiced view on whether the Con Court should be hearing tax matters, unless it goes to the Bill of Rights, where, you know, taxpayers are persons who are entitled to protect their rights. For example, seizure of property and things like that. But if it's a pure tax matter, I wonder whether the Con Court should entertain those kind of things, because is it of general public importance? Or is it really more for the litigants themselves who dispute in the tax? So it is a vexed point.
And who can represent a disgruntled taxpayer?
Look, when we're talking about tax court, the High Court recently ruled that in fact you do not need to be an attorney or advocate to appear in the tax court. I distinguish tax court from other courts. And it was held in this case that a representative of the taxpayer, who may have, you know, accounting and or hopefully has some accounting, legal and tax knowledge, can appear. So simply put, a layperson can appear in the tax court because the tax court is seen to be a creature statute. It's not actually technically a court of law. It's more akin to a tribunal. Obviously, at a practical level, though, if you got someone representing you in the tax court, it means you're talking about a dispute of $1 million plus, usually. That person should at least be a registered tax practitioner and have some knowledge of proceedings in courts.
Okay, before you tell me that everyone's circumstances are different, can you write off these costs against your taxable income?
Costs of litigation.
Yeah.
Generally, well, again, if the dispute pertains to a revenue or income dispute, there's an argument for that. If it goes to whether the matter is of a capital nature, then I would say generally no.
Gordon, I've got one from Milton.
Yeah, I was going to just add, I would agree with Tony. It's got to fall within the general deduction formula.
Gordon Milton says, I worked in Australia for a while and accumulated some superannuation benefits. How do I write this in my will, and will this form part of my estate as I currently reside in South Africa?
Bryan, to my knowledge, the answer is no, because a superannuation is more aligned to, if I could use an analogy, a South African retirement annuity. So it means that, so unlike the other assets that he may have in his name, they're not actually considered to be part of the deceased person's estate. And that's because superannuations are legally considered in Australia to be held in trust until the person is actually eligible to access it. So what I would suggest is that he rather nominate, I think you said Milton. Milton actually just nominates the beneficiary now. If he doesn't nominate the beneficiary, then the super fund will just simply follow the relevant laws to decide who receives the balance. That could be either one or more of his descendants, or even a legal personal representative.
Okay, forgive me to our viewers. I'm going to forfeit my end result because I've got one last question for Tony, and this is from Paul. He says, I'm retiring and taking 1/3 of my retirement fund in cash. If this is added to my other assets and I die, will this cash, which I've already paid tax on, also attract estate duty?
Well, the general rule is that a retirement fund, including a retirement annuity, so for example, pension fund, is actually exempt from.
Here he's taking the 1/3 in cash.
He's already done an encashment.
Paid 36% and now another 20%. Okay.
Well, they're different taxes.
Yeah.
Yeah, different taxes.
They're different taxes, so you can't look at them that way. Once you've encashed it, to me, that's as part of your estate.
Yeah.
Okay.
So, Bryan, it's the equivalent of saying I paid employee tax on my salary and I took my savings and went and bought an investment. Would that form part of my estate? Yes, it would.
Okay, well, we've run out of time. Just for our viewers to understand, it's important to note that our program is provide information and should not be construed as advice. Next week's program, we will be dealing once again with financial planning, and if you need to get hold of me, my details will appear on the screen. Finally, please, if you've got any questions on anything to do offshore, onshore, Tony's available, Gordon's available, and Harry, who's not with us tonight, I better just mention Harry Joffe as well, and any other professional you may use. Thank you for joining us. Good night.